point of marijuana prohibition. But in this case, the government didn't put any evidence in that it achieved that. We put in the Senate report, we put in evidence that it in fact didn't achieve those goals, that we weren't deterring people. In fact, we're forcing people to the black market like Mr. Bennett and like the medical marijuana cases say deficiencies in the medical system do. They force people to the black market. That's contrary to the legitimate state interest fostered by legislation and therefore arbitrary. And we also said it causes grossly disproportionate effects. There's no evidence that preventing Mr. Bennett from practicing his religion is in fact going to benefit his health, stop the black market from existing, or any of the kind of things that you're allowed to do in the course of legislation. In fact, the evidence is quite to the opposite.
Right.
And the effect of that prohibition is to absolutely deny him the right to practice his religion, which is a fundamental freedom here in Canada. It's fundamental to our very conception of what it means to live in a democracy that has some respect for the rule of law, and it's forcing him not to do that. So that's the Section 7 problem. And then we get to Section 15. And Section 15 of the Charter is the equality guarantee. And essentially we've analogized to sacraments that are permitted. You're permitted, even as a minor, to consume alcohol as part of the Catholic tradition, the sacrament and the ceremony there.
Yeah.
And you're entitled to, as a Native American, or Native American in the United States, but of course you're a First Nations person, entitled to ingest peyote as part of your religious sacrament. And we said too that because Mr. Bennett's sacrament is treated differently, because it's controlled, because there's no exemption process, he's being discriminated against on the basis of his religion in a manner that really speaks to his fundamental human dignity. I mean, when you tell someone that their religion is unlawful, when you tell them they're a criminal for engaging in an act that harms no one else, that simply opens up their connection to the divine within themselves or out there, you crush their spirit, you crush their human dignity. And we say that that's a violation of the equality protections of the Charter. And I feel very confident that the court's going to agree with us on those points. What we're left with then is, if it is in fact a violation of Section 2 or 7 or 15 or all of them combined, as we've argued, the government then is entitled to justify that. You're entitled to override those infringements under Section 1 of the Charter in a free and democratic society. But here the burden shifts. Here the government has to justify it. In the sections 2, 7, and 15 analysis, burdens on Mr. Bennett here, through his counsel, me, to demonstrate that the infringement in fact is occurring. We shift over to the other side, and they must demonstrate on a balance of probabilities that they're able to justify the legislative scheme or the minister's decision to deny Mr. Bennett the exemption. We say they can't do that. And one of the interesting facets of this case is that we put in this evidence of the failures of prohibition, the Senate report. We've relied upon that, and when I asked Health Canada's witness about the efficacy of prohibition, is it meeting its objectives, her counsel directed her not to answer those questions. So the government hasn't even put in evidence related to the efficacy of prohibition. We gave them an opportunity to do so. They chose not to do so. And so in my view, it's one of these sayings in law that cases are decided on evidence, right? And so even though other cases may find different things, what you see is this case has got to be decided on the record evidence of this case.
Yes.
And I feel very confident that with respect to the record, we've done the best job we can. And it's going to be a question for the judge. Does the infringement, is it rationally connected to the purposes of the legislation? We say it's not. We say it doesn't deter people, it doesn't promote public health, it doesn't protect public safety, and in Mr. Bennett's case in particular, it does none of those things, in fact, just the opposite. So it's not rationally connected. Does it minimally impair his religious rights? Is there another way to still achieve the benefits sought by the legislation and protect his religious freedom? And we say there is. I mean, marijuana is subject to a comprehensive exemption scheme. Comprehensive. The minister can give exemptions. And there's no evidence in the record suggesting why there can't be an exemption scheme for religious cannabis users.
Right. If there's already one for peyote and other things like that.
Ayahuasca, there's been tentatively granted for ayahuasca, which contains the powerful psychedelic chemical DMT. I'd like to add too, the government's case has been mostly on keeping evidence out. They prevented us from entering Professor Scott Littleton's affidavit, and then they prevented us from entering material regarding their tentatively granting of an exemption for ayahuasca. And so their whole thing has been trying to keep the truth down, and this whole process seems to be, like it's more of a game than really getting down to the legal questions and stuff like that on Health Canada's part, And another thing is, the Canadian Charter is based on the supremacy of God and the law. And I don't care what religion you are in, any religion on earth, if you believe in that God, you better believe that God created the plants of the earth. And if the government is going to take a stance against God's creation and the gifts, which are a natural right, God-given right, even in the Christian Bible, which seems to be the basis of much of our judiciary system in Canada, where it says in Genesis, God, I granted you every herb-bearing seed, it's pretty clear what the stance is there. Then they're taking a stance against God, and I'd say that, this case is more about, it doesn't have any effect on cannabis being the tree of life, doesn't have any effect on my sincerity. It's more a statement on the court and their claim of God's supremacy and how they react, and so win or lose, it's a statement on them and not on any of this stuff, any of my beliefs or anything. My life goes on the same as it did before. I'm under prohibition now, and I have been for the last 20 years, and if that's to continue, well, I'll be continuing on the same path that I've been on for the last 20 years.
So, moving into where things are going now, there's some recent developments, there's some new stuff you guys are bringing in, and there's some stuff coming up. Maybe get into that stuff a little bit.
Yeah, well, I've given the summary of the argument, but essentially what happened since the time we filed the first memorandum of fact and law some months ago, we've had 3 court decisions come down that are all relevant, and we filed new pleadings on each of those, and because of the multiple filings, the justice has actually just had us summarize everything into one new pleading that I finished about a half hour ago. I'm wearing my Shiva shirt here in honor of today's filing of the document that we're going to be arguing upon starting next Tuesday. We'll be making our argument downtown Vancouver in the federal court. It is open to the public. You certainly, viewers are welcome to attend, attend if they're interested.
Yeah, come on down.
Obviously be respectful to the court's proceedings. It's going to be taken, I'm confident, very, very seriously by the courts. It's been well prepared and well argued on both sides. I feel very confident that we've put our best foot forward. And, recognizing it is a first step in a process as well. It's a federal court trial decision. This decision is subject to an appeal to the Federal Court of Appeal, which itself is subject to an appeal to the Supreme Court of Canada. And so it may be that we're going to be joining potentially other cases on the way up the ladder. The 3 cases that were decided since we filed were the Murnau decision about medical marijuana, and I've talked about that on my show, Legalese, and your viewers can certainly look that up.
Right.
The Karagani decision, which was a spiritual use decision out of Ontario, that case is not resolved yet at the trial level, as far as I know, and no appeal date's been set. But in that case, the trial judge found Section 2 is violated, but on the facts of that case, Section 1 justifies the prohibition. And thirdly, the Insight decision, the Hotel Society case about safe injection sites. And that really has a lot to do with the fact that the minister's exercise of discretion in granting or denying exemptions has to comport with the Charter. And has to be a decision that doesn't deprive, for example, you of your fundamental Section 7 or 2, or I say 15 rights. So the new pleading's gone in. It's going to be a busy weekend getting ready for oral argument. We've got a day and a half set aside, so we have half of that, 3/4 of a day. So our argument will commence sometime around 9:30, 9:45. Court opens at 9:30 but the actual argument is usually some preliminary, so around 9:30, 9:45. Have until probably about 1:30 that day to put our argument in. Then the other side responds to it. There may or may not be a final reply by me on Chris's behalf at the end of the proceedings, and then the judge will probably take it under advisement and issue a decision at some point in the future. So we're very excited.
And what would the decision really mean ultimately? I know it would mean a personal exemption for Chris, but could that be used for other exemptions for other people? Would that set some sort of a precedent?
Well, it really depends on what the court does. I mean, the court has a number of options. The court can, obviously the court can find against us, and then it ends at that level. Or if the court finds for us, the court can send it back to the minister for reconsideration of the denial, or grant Mr. Bennett a constitutional exemption while any appeals are pending,
Right.
or declare the prohibition to be invalid as applied to Mr. Bennett or generally, and declare it invalid on any one of a variety of grounds. And at that point, the declaration of invalidity would probably be suspended to allow the government to step into the legislative void and perhaps craft a regulatory regime. So it's really open to the court to do a number of things with this case. And it'll be interesting to see what happens.
Would losing this case have an effect in the same way? Would it mean that other people wouldn't be able to push forward with this kind of thing, or would it limit anything like that? Or could, another person go along and do this at any time afterwards?
Well, certainly in terms of precedential value, let's assume it gets appealed and we lose at the Court of Appeal, because that's where you have some more substantial precedential value.
Right.
It would be difficult for people to overcome that depending on the grounds for the decision and what their evidentiary record looks like. I mean, you look at a case like Murdoch, for example. It's about the fourth challenge since Parker to the medical marijuana regime, and all of them have argued the physician as gatekeeper requirement is a barrier to access and makes the scheme invalid. And in Hitzig, trial in Court of Appeal, that was a no. Didn't find the record was sufficient to make that case out.
Right.
But in Murdoch, the court looked at the record and said, look, we have different evidence. And on the evidence in front of me, this is the conclusion I'm going to reach. So it's always open to future litigants to bring more evidence in, different evidence in, and to try to make a case. If you get into whether or not you're going to overturn case law on the law as opposed to the facts, that's where precedential value really steps in.
Fantastic. So, well, that's good. Sounds like there's lots of positive things that could come out of this. I'm excited to see what happens.
Absolutely.
If people want to help you guys out in any way, other than just coming down and seeing what's happening there, can people, I don't know how they would help you guys. Can they donate to you, Chris, in any way?
Buy my
Check
books,
out your
man.
website, buy your books.
Can always, that always helps. You can get something back.
Drop your website.
ForbiddenFruitPublishing.com, or you can find my books on Amazon. Cannabis and the Soma Solutions, the latest one. That's the one I'd probably recommend you get the book first before I get any of the other ones, for sure.
Well, and obviously you can always use this case as an opportunity to write to your elected officials and talk about the need for change in our cannabis laws, either specifically related to opening up religious exemptions and stop infringing on people's freedom, or generally cannabis prohibition as a failure. I mean, this is a good opportunity to begin a conversation. You might as well use it as such. You can always support that kind of work at whyprohibition.ca.
Yeah.
I'm going to be launching a new website soon at TousawLaw.ca, so
nice.
Check it out. And obviously support any of the various activities that Chris or I or you, Jeremiah, are involved in, because we're all fighting really for the same cause at the end, which is the liberation of people that consume cannabis for any purpose.
Make way for the tree of life, man.
Fantastic. All right, guys. Well, thanks a lot for coming on.
Thanks for having us on, Jeremy.
Always a pleasure.
And we'll keep touch on what's going on. We'll definitely be there on Tuesday, and we'll keep you guys posted.
Thank you.
Thank you.